Today we're going to talk about the rules of evidence and the various objections that might come up in a criminal trial. The rules of evidence determine what information is admissible and allowed to be presented to the jurors at trial.
There are a lot of rules of evidence, and the rules are pretty complicated. We're going to try to break down some of the more common ones. One of the most basic rules of evidence is that for evidence to be admissible, it has to be relevant. For evidence to be relevant, it has to help one party prove a fact that is related to the case, or it must cast doubt on a fact that the other party is trying to prove. This is an important rule because we want jurors to make their decision about guilt based on the things that are important to the case. We don't want jurors to make a decision about whether the defendant is guilty based on something that has nothing to do with the case.
So, for example, if the defendant were charged with stealing a bike, it would not be relevant for the jury to hear about the defendant's favorite music or song. Instead, it would be relevant to know, for example, where the defendant was when the alleged theft took place, and where that was in relationship to the missing bike.
Even if evidence is relevant, it can still be excluded under other rules. For example, evidence presented by the attorneys or witnesses might be inadmissible or not allowed in a trial if it's confusing or misleading, is only slightly relevant but has a high likelihood of causing unfair prejudice, or if the witness is speculating or does not have personal knowledge about what they're testifying to.
A really important rule of evidence is that hearsay is generally not admissible. This rule says that statements made outside of court that would be used to prove something true are usually not admissible. Essentially, the rule is trying to make sure that the jury does not consider rumors or third-hand statements. An example of this would be if my friend James and I witnessed someone steal a bike, and James said to me, "Hey, that person stealing that bike looks a lot like my classmate Jessica." If Jessica gets charged with stealing the bike, and James is not available as a witness, then the prosecutor cannot ask me to testify about what James said. That would be hearsay.
There are a lot of other rules of evidence and exceptions to these rules. Throughout the jury trial, you will hear the lawyers objecting to certain questions or evidence from the other party by saying objection. Sometimes they will explain their objection, other times they won't, because there's an assumption that everyone involved knows the rules. Ultimately, the judge would rule on each objection, deciding what evidence the jury gets to consider in making its decision.